Hello, welcome to the second part of our discussion here on the kind of national principles of the U.S. And just to refresh your memory, we are in the third module, and that third module is about the where of American politics. And the reason I've decided to characterize it that way is that so much of our national political culture is centered around the Constitution, that we need to spend at least this one module unit on it. We've already done one module on checks and balances between the branches. This is somewhat of a revisiting of that, but it's more than that. It's a little bit of the why. It's why there has been this political culture that's emerged between the two branches and the three branches and all of the different states. And in addition to that, I want to talk about how the Constitution emerged the way that it did. I'm not going to tell much of a story, but basically I want to go over these concepts on the board here today. The first thing I want to acknowledge is to expand on something I talked about in the first lecture, which is that James Madison, the author, in many ways, the principal author of the U.S. Constitution, and someone who took such copious notes that were found after his death, they are now the definitive kind of history of the Constitutional Convention in Philadelphia in 1787. He just seemed like he was just writing all the time. He was transcribing almost everything that was said by every speaker at the convention over those several months in the summer of 1787. And he used those notes and that understanding certainly in a way that was constructive for writing the Constitution itself, and then also for really selling the Constitution. He and another participant in the convention, Alexander Hamilton, as well as a third person who played a lesser role, John Jay. But mostly Hamilton and Madison wrote this series of Federalist Papers. They wrote them anonymously, and they wrote them in a way that was destined to, be recorded because they wrote them in newspapers, and they were there for a specific purpose. The reason we have the Federalist Papers is because there was a group of people who needed to read them, and those people were voters in the state of New York. And it wasn't really all of the states, it was just the state of New York, because the way they set up the Constitution to be approved and ratified and take effect is that the states needed to be the ones to call conventions and agree to or ratify this new Constitution. And the Constitution, when it was written, said that as long as there were 9 states out of the existing 13 that ratified the new Constitution, that it would become law. However, the largest states were really deal breakers. New York was so large in terms of its population at the time that it and Virginia were the 2 largest states. And they both also served as geographic barriers to the rest of the states in the South and the North, respectively. So if New York had said no, if New York had voted the Constitution down, it would certainly not have existed further. And if seemingly, probably for Virginia, the same is true. But so what each state had to do was to create a new assembly and elect new representatives in whatever way they saw fit to go and debate the new Constitution and vote yes or no. That's it. They basically had to create a whole new legislature in 1 year in order to just vote on this one item, which was important. So maybe it was not disproportionate. So in New York, because it was such a central player, Madison and Hamilton decided to just, at the time, do kind of a media blitz. But the media wasn't radio and TV and internet; it was just newspapers. And so every time there was a newspaper published, you saw almost for those several months, you saw a new justification of some aspect of the Constitution written by one of the principal authors. And so the Federalist Papers are today seen as just this long work. There were 85 of them, and 85 basically essays on individual topics that relate to the Constitution. So if you include the Federalist Papers as part of the Constitution, even though the Constitution itself is only, depending on how you print it, it's like 7 or 8 pages. It's much longer. It's closer to 200 or 300 pages or so. So the Federalist Papers are kind of considered part of the document because they're part of the contemporary reasoning by the same authors. So that's why when we say the Federalist Papers, we're talking about the justification for the Constitution itself. And so one of the Federalist Papers that was written, and we'll get back to that idea about New York ratifying in just a few minutes. So one of the ideas that Madison had to reconcile was this idea of factions. And factions he had seen in Virginia and especially, in reading history, but also British history, especially within Parliament. He saw factions developing, and factions were just a word of a group of people who were competing for power with other groups. And those groups, he saw, could never come together in a way that was harmonious for the entire state. And so he decided to create this, as I said in the other video, recognizing that if men were angels, no government would be necessary, and that ambition must be made to counteract ambition. We must create this system of checks and balances, especially between people in individual states. So we don't want Georgia, for example, taking over the United States. We don't want New York even taking over the United States. We want them to have to form majorities with each other and compromise their interests, so that we will have a country, basically. And so he used this idea of an incentive to create majorities within every aspect of the Constitution, particularly within the House of Representatives and the Senate, to build coalitions between states and between representatives within states. That this is something that later on social scientists would call the collective action problem, and Madison's use of ambition counteracting ambition is called a selective incentive. An incentive to try to get around this collective action problem, that it's always more rational to go out on your own. It's almost always more rational when you're within a group of people or in a society where you have this collective problem. It's always more profitable and more it's more profitable and it's more rational then for you to step away from the group, let the group do its work, but you go off and do something else, and maybe you'll benefit from that group's work, but you won't. But what you won't do is suffer from its failure. So that's the idea of if it's rational then to always be out on your own. Madison's idea was to recognize that rationality and harness it for the good of the whole. So you're not always just trying to cooperate with people, you are rationally fighting them in order to create some outcome that's better for everyone. So that's kind of what the collective action problem is and continues to be in, for example, social justice organizing, that kind of stuff. But definitely works well in terms of the market, in terms of undermining public goods occasionally. So that's the idea behind harnessing factions. I want to take a second and we should be taking more than a second, but to reiterate something I said in the verse video, which was there was, of course, racial and gender political differences and social differences in the U.S. at the time of the founding. And women were not allowed to vote, and of course, African Americans were not citizens, so they were just enslaved Africans and descendants of them at the time. But so there were black folks, and there were women, and there were other enslaved people at the time, and they were certainly not allowed to vote. They were not allowed freedom of any kind. And one thing that came out of that debate within the Constitutional Convention was two compromises between the North and the South in the Constitution. One was that the slave trade, the international slave trade, the act of bringing new, forced laborers from other continents and other countries into the United States for the purpose of slavery, was going to legally end in 1808. And so there was this 20-year sunset on the international slave trade. That's one compromise. The second compromise, which, by the way, Thomas Jefferson agreed with, and as president he implemented, but still he was a slave owner himself. So, but the other thing is that what's often the source of a lot of confusion, the 3/5 compromise. So here's the problem. So between the North and the South at this point already see themselves as kind of somewhat opposed entities. The North realizes that it depends on the agricultural labor of the South for its textile exports, but still culturally feels very alien to the South because of their reliance on this institution already, even at this point in history. And so the North, there were a lot of people who were against slavery in the North, and so that was the result of the slave trade, was really the compromise there. But there was something the South was demanding, which was that because we have all these people that we have enslaved in the South, we want to be able to count them in the census for the purposes of representation in the House of Representatives and the Electoral College to elect the president. And so the North, of course, says, no, we don't want to recognize the people you've enslaved as people, because then you'll be entitled to more representation in the House and the Senate and the Electoral College. I'm sorry, just the House and the Electoral College. But you'll be more entitled to representation, but those people will not be able to function as citizens. And so how is that fair? And so instead of working to resolve it in the direction of saying, well, maybe we shouldn't allow those people to be enslaved, they instead said, okay, South, you basically win, almost. You can count that whole population of people, but it'll be counted on the basis of 3/5 of those persons. So you're getting the majority of what you want, is you're being able to count all of those people, but you're not obligated in any way to free them. So that was the compromise, but it basically was the South winning. They got more representation in the House and the Electoral College, even though they had no obligation to treat the persons they were recognizing as persons as persons. So that's why there's all these references to the 3/5 compromise and everything. So that was one of the compromises that came out of the Constitutional Convention. Another one was the Virginia Plan and the New Jersey Plan being merged into the Connecticut Plan. Or the Connecticut Compromise. The Connecticut Compromise was simply grafting most of the Virginia Plan, but also a little bit of New Jersey. So here's what that was. I'll come back to what they were kind of departing from. But New Jersey liked the system the way that it was. They liked states all being kind of their own masters, their own sovereigns. And Virginia wanted to more forcibly integrate all of the states in the Union into more of a population-based representation. So they wanted the House and the Senate to be more based on population, both based on population. And the New Jersey just wanted to stick with everything the way that it was, with just one House, and it was all state-based. These were two very different positions, and Virginia was called Virginia Plan because Madison was the one who wrote it, and New Jersey was just a delegate from New Jersey. But Roger Sherman was this Connecticut representative, and he said, well, we can go further than New Jersey Plan, but maybe we don't need to go do everything that you want, Madison and Jefferson. Jefferson wasn't there, sorry. So instead, why don't we just say the second house will just be based by states, and you'll still get pretty much this whole idea of factions and checking each other and all of that and so on, and more of population-based representation in the House and the Electoral College, but in the Senate we let them keep their state representation. So I don't know if it's fair, but it's acceptable. And so that's what they came up with. So the Connecticut Compromise is an additional compromise. So the 3/5 Compromise is one that allowed the South to count the people it enslaved as 3/5 of their population and still not give that population any new freedoms whatsoever. An additional, separate, distinct compromise is the Connecticut Compromise. And that's the one that brought together the idea of a population-based House and a state-based Senate together. Because ultimately Madison got most of what he wanted anyway, and because he was from a more populous state, and he and Hamilton both saw that as much more advantageous to build a national government of people based on people, and based on more of population and less on these state entities, was a giant step in the direction they wanted. And so one of the things that had to take place was this idea of national supremacy, because as it was, any state could really torpedo anything that the United States was doing from the time that it existed, from the time it declared war against Great Britain and declared independence, 1774 all the way to 1786, really. But these 1781 kind of final Articles of Confederation that were written allowed for two ways of passing agreements between states. For one thing, every state received one vote, no matter how many delegates you sent to the capital, which at the time was Philadelphia and became New York for that time as well, for a short time in the beginning. But also that not only did they get one vote, but also any one of those states could just agree to not follow something that was done. And they also needed a 9/13 majority, 9 out of 13th majority in order to pass anything. And they needed to, and for important matters, they made it unanimous. So really, functionally, any state could veto anything that the federal government wanted to do, the Articles of Confederation federal government wanted to do. But also, they could simply not obey them, and there was nothing really that the existing federal government could do. There wasn't much of one. The federal government was just a place where the states could meet and discuss differences. So that's more of a UN, really, than a Congress or a federal government of any kind. So there was no national military, no national treasury, no national roads or anything at all. And so, there was a real danger that they were going to start going to war with each other, and that would have made them really vulnerable to their still existing neighbors, Britain and Canada, and Spain, and eventually France to the west and south. So they were really, in terms of who owned the colonies that were next door to them. and not to mention, of course, the indigenous Native Americans that were being colonized in all of these places by Spain and France and the U.S. and Canada. So at any rate, the Articles of Confederation were a terrible system, and really couldn't call it even a system, let alone a government. And so you'll see more of this in the video that I showed you about how the Articles of Confederation were weak and how they needed something stronger. And so when they met in 1786 to discuss differences in Annapolis, Maryland, they eventually said there's too many differences and there's too many problems for us to really resolve this here. Why don't we call a new convention whose sole purpose is to fix the Articles of Confederation? Madison said that would be the business of May next, when we met in May in Philadelphia. So they very quickly scrapped the Articles of Confederation early on in their debate, and they said we need to just write it fresh. So because they realized just how vulnerable they were. So at one point, something you should know is that because there was no treasury, no real unified economic policy, there were hundreds of different currencies in the U.S. There was no one U.S. dollar at the time. It was all just sort of trading in whatever forms of credit and gold and silver coin maybe that different banks chose to honor. And so that's a terribly fragmented and precarious economic system, for one thing. But also it bred an equally precarious military situation, because there was no reserve army. It was all just sort of volunteers. And so all those people who were, enlisted people or part of the militia during the Revolution went back to their homes, usually their farms, and they had nothing to show for it. And if they thought that they could get a better deal from, going to join up with someone in another state and trying to take over part of this state, it just became a mess. Like in New York and New Hampshire were claiming territories in Ohio as part of their own states. And so that was not resolved really that was resolved by the Northwest Ordinance during the Articles of Confederation. That's the one thing they did. They divided up the modern Midwest. So Ohio and Indiana and Wisconsin and Michigan all really came from that Northwest Ordinance. But at any rate, after the Northwest Ordinance, they couldn't cooperate on anything else. And so the Articles of Confederation, when they were scrapped, one of the things they decided on that Madison really fought for was this idea of national supremacy, which I explained in the other lecture. This idea that whenever the state and the national government come into conflict, the national government has to always win, legally, constitutionally, politically, socially, all of it. You have to recognize that the national government is supreme and superior to the state governments in every way. And if you don't do that, then you're always going to have this veto of both passing laws and implementing laws. So you simply can't allow one state to be more powerful than the rest of the states combined and unified. Let me talk about some of the other things that came out of this. One is and let me come back to this in a second, the elastic clause was another clause that is often mentioned in Article 1 of the Constitution. The elastic clause is also called the necessary and proper clause, and it often is in conflict with, states' rights. So the elastic clause says that Congress may pass laws pursuant to carrying out their existing powers. So if there's anything that could be interpreted as loosely related to something that is in Article 1, Section 10 of the Constitution, or any of that list of powers that Congress has, and that is, for example, to create post roads or to coin money, to regulate weights and measures, like all of that stuff. As long as it relates to something there, anything that's necessary and proper to carry out those functions and those powers are what Congress is empowered to do by the Constitution. Now, this is sort of in opposition to one of the rights that is in the Bill of Rights, and that is two of the amendments in the Bill of Rights, the 9th and 10th Amendments, that came later. And the 9th and 10th Amendments say, respectively, the 9th Amendment says that anything is, well, the 10th Amendment, I'll just say the 10th Amendment, anything that is not explicitly banned or explicitly mentioned as a right that the federal government has are rights that are reserved for the states or for the people. So anything that's not mentioned here, any right that's not mentioned here, whether it's your right to, right to take a walk, or your right to, brush your teeth or shave in the morning, anything that is not listed there, you have the right to do, because that's a right reserved to you that's not explicitly taken away by the Constitution. And so the Elastic Clause, has attempted in successive order through every generation to expand the reach of the federal government's authority, because the federal government becomes intertwined with the economic and social structure of the U.S. in such a way as that it seeks to expand its power or its influence or solve new political problems in a way that requires government action. And that is often in conflict, for example, with civil rights. So during the Civil Rights Movement, the Elastic Clause was part of what enabled the Civil Rights Act, which banned the ability of people in public accommodations to restrict entry to customers on the basis of their race or religion or national origin. The Civil Rights Act of 1964 was criticized mostly by people who believed that states should be able to determine what the rights of its citizens are. And states should be able to have rights to be able to create to foster a business climate, for example, that allows its shopkeepers to continue this practice of segregation that's been going on legally since 1890 or so. So often in rhetoric and politics, the Elastic Clause has been in direct conflict with the States' Rights Clause. And the clauses themselves don't fight, but people kind of use them as justifications for their own political interest. So even though looks like a legal dispute, it's really a political dispute for the goods that people want to preserve, whether that's civil rights for African Americans or states' rights for states and the kind of commercial and kind of business authorities that are influential in especially the southern states, the Deep South, during the Civil Rights Movement. So anyway, so I wanted to mention at least the those two clauses. And by the way, the Commerce Clause, something else we'll mention during the Civil Rights and Civil Liberties chapters as well. So, let me talk a little bit, just for about 10 more minutes, I think I have, to talk about Bill of Rights and republicanism and representative democracy. So, the Bill of Rights was this kind of addition, these 10 amendments written by Madison in the first Congress after it was seated in Philadelphia, and it was meant as a compromise. It was meant as an allowance to people who had voted for the Constitution on the basis of, look, we have rights and we expect those rights to be recognized in the Constitution. Whereas the fear, at least expressed by people like Alexander Hamilton, was that if we listed rights, then there might be some tendency to only recognize those rights and not recognize any rights that we tend to miss in the first go round. So we'd rather not write them down. Critics of his would say, no, he was just trying to prevent us from having any rights, which is why they wrote the 10th Amendment, which is to say that explicitly to solve this problem. The 9th and the 10th Amendments to say reserved powers for the states and to the people, anything that's not mentioned here. So the Bill of Rights, you'll see in the video about the New York ratification debate, which is what that third video is, called An Empire of Reason. It was commissioned about 30 years ago by, it was based on a grant. I think it required about $500,000 to make. So it was a relatively small grant, but had all these volunteer media personalities in it at the time, some of whom you might recognize. At least I'm old enough to recognize some of them. But it was even about 10 years before I watched it was made. But I've used it in some of my other American government classes because I think it's, it's not the best acting you'll ever see, but it's fun to kind of see in a relatively modern context what kind of issues they were really talking about back then in 1788 and 87. And what it does is it shows you, the Federalist Papers were these things that were designed to show people that, look, there's nothing to be afraid of. All we're after here is a little bit more stability and a little bit more security for government. It's not a return to tyrannical monarchy like we had under Great Britain. It's really just a maturation of our political culture to the point where we can be masters of our own destiny. That's the case they were making. And what most people you'll see are afraid of is a return to tyranny and a return to a kind of monarchy or an unrepresentative government that doesn't serve the interests of most people. And at this point, most people were farmers. About 80% of people or more. I always get that number wrong, but the vast majority of people in the U.S. were just small farmers, and they just did not want to pay additional taxes. They didn't want to fight in additional wars. They just wanted to be left alone, and they thought that's what they got with the Articles of Confederation. But what they really got was a system of almost total anarchy. The states could not keep order. They could not guarantee freedom, certainly, or order. They didn't have any money, and they didn't know what money was. They had no security. And so it was only a matter of time before all of those small farmers were encroached and taken over by either France or Great Britain, probably. So that's why they needed to do what they did. And I think it's fair to say that if they hadn't passed the Constitution, that the U.S. wouldn't exist today. The Articles of Confederation would be a footnote in French or British history. Finally, there's this distinction that often comes up when I teach American government and when I see people talking about American government, about the distinction between a republic and a democracy. It's maybe my favorite, actually quote that people give each other. Actually, the U.S. is not a democracy, it's just a republic. So a republic, for our purposes and the way they understood it, is meant to be a representative democracy. A republic is, yes, a system of laws that doesn't necessarily rely on popular elections and enfranchisement and representation of all interests within a governing space. However, this particular generation of founders and group of people did make a lot of references to the idea of democratic principles and natural rights of all, they said mankind at the time. They would say humankind today, maybe. So the fact that they were attempting to incentivize representation meant that their entire orientation was toward democracy. And I think it's borne out by the culture they created, which has been There are a lot of issues and problems with American political culture historically, but it's definitely, I think, completely uncontroversial to say that, and if not, then to me it's self-evident that if American political culture didn't exist the way that it did, then there would not have been at least the germ of democracy implanted in the minds of the founders and the people who understood what they were trying to do. Excuse me. What they were trying to do. Then there wouldn't have been an enfranchisement of non-property owners in the 1820s. There would not have been this kind of eventual enfranchisement and freeing of slaves and of formerly enslaved people. And there would not have been disenfranchisement, at least in the same way at the national level, of women. So anyway, I guess what I'm saying is republicanism is just meant to be a historical kind of reference to a non-monarchical system. It's really the only kind of bare minimum they were trying to accomplish with the Constitution. But what they ended up doing was having a somewhat representative democracy that gained representation as they went forward. And finally, there is one more thing I have to mention, is that amendments are a different concept here than anywhere else. For example, in Great Britain, there is I went over this somewhat in the judicial lecture in the first unit, but our kind of constitutional process is such that we have to amend the Constitution. We have to have a 3/4 of the states after a 2/3 majority in both houses. That's very hard to do. That's near consensus numbers, and as Madison has demonstrated, there's always conflict. So there's almost never that kind of consensus, which explains why the Bill of Rights, if you count it as one, those are 10 amendments, but then 17 times additionally to that are the only times in the U.S. history that we've changed the Constitution. So there have only been, in addition to the Bill of Rights, 17 amendments. So there's altogether 27, and so that means even if we count it that way, 27 times changing a 4-page document is absurd in a 200-year history. So, that's why we've empowered the judiciary to say what the law is and what the Constitution is for every generation. And that's why we have a system of laws that does not need to be amended. But otherwise, we might be more like France, who's had, in the same span of time, they've had about 10 different constitutions. Okay. Thank you for watching this about the Constitution. I'm sure we'll talk further about some questions that I didn't address, or possibly ones that I did in this video. So I look forward to our conversation and wish you well. And please let me know if you have any questions. Thanks for watching.